Good day, everyone. Welcome to discussion and answer video where we will be discussing the judicial branch as outlined in the 1987 Constitution. We'll be exploring the role of the judiciary, the qualification of judges, and the scope of their jurisdiction. If you're curious about the third and final branch of the Philippine government, you've come to the right place. Let's dive in. Do read the disclaimer. What is the scope of judicial review in the 1987 Constitution? It covers the adjudicatory power, its expanded power of judicial review, and its incidental powers. What part of the government is judicial power vested? Based on Article 8, Section 1, judicial power is vested in one Supreme Court and such lower courts as may be established by law. What constitutes the judicatory powers of the Supreme Court? First, to settle actual controversy involving rights which are legally demandable and enforceable, based on Article 8, Section 1, Paragraph 2. What, what constitutes the expanded power of judicial review of the Supreme Court? Based on Article 8, Section 1, Paragraph 2, this is to determine whether or not there has been grave abuse of discretion amounting to lack or excess of jurisdiction on the part of any branch of the government. Take note that the second paragraph effectively limits the political question area that was forbidden territory for the courts. This is an added provision in the 1987 Constitution which broadens the scope of judicial power. What constitutes the incidental powers of the Supreme Court? Those which are necessary to the effective discharge of the judicial function, such as power to punish persons, to judge in contempt, and the power to issue restraining orders or prohibition and injunction, the aid of the power of judicial review. What are the requisites for judicial review? First, there must be a case ripe for adjudication. Second, it should be raised by the proper party, which means the party must have locus standi in the action. Third, it should be raised in the earliest opportunity. Fourth, decisions on the constitutional question must be determinative of the case itself. It is the lis mota. Discuss the void-for-vagueness doctrine. A statute or act suffers from the defect of vagueness when it lacks comprehensible standards that men of common intelligence must necessarily guess at its meaning and differ as to its application. It is repugnant to the Constitution in two respects. First, it violates due process for failure to accord persons, especially the parties targeted by it, fair notice on the conduct to avoid. And second, it leaves law enforcers unbridled discretion in carrying out its provisions and becomes an arbitrary flexing government muscle. Discuss the overbreadth doctrine. A governmental purpose to control or prevent activities constitutionally subject to state regulation may not be achieved by means which sweep unnecessarily broadly and thereby invade the area of protected freedoms. What is a political question? It is a question the resolution of which has been vested by the Constitution exclusively, first, in the people in the exercise of their sovereign capacity, or second, in which full discretionary authority has been delegated to a co-equal branch of the government, based on the case of Tanyada versus. Is the judiciary prohibited from reviewing political questions? No. The second clause of Section 1, Article 8 effectively limits the political question, which are forbidden territory for the courts, specifically the power to determine whether or not there was a grave abuse of discretion. The court may now determine whether there is grave abuse of discretion amounting to lack or excess of jurisdiction on the part of any branch or instrumentality of the government, based on the case of Francisco versus House of Representatives. A Courts may interpret the meaning of disorderly behavior and the legislature's power to suspend a member, true or false. False. It is a political question. The interpretation of the meaning of disorderly behavior and the legislature's power to suspend a member is a matter left to the discretion of the legislature, based on the case of Osmeña versus Pendaton. The suspension of the privilege of writ of habeas corpus is a political question, true or false? False. In the case of Montenegro versus Castañeda, the Supreme Court ruled that the suspension of the privilege of writ of habeas corpus is not a political question because the Constitution sets limits to the executive discretion on the matter. Courts can intervene in a case where the House of Representatives was said to have disregarded its own rules, or false. False. It is a political question. Whether the court could intervene in a case where the House of Representatives was said to have disregarded its own rule, the court was held to have been without authority to intervene, based on the case of Arroyo versus De Venecia. Hearing the issue of constitutionality of the pork barrel system is a political question, true or false? False. It is not a political question based on the case of Bellica versus Ochoa. Proceed. Courts can rule on another state's recognition of diplomatic immunity, or false. False. It is a political question. In the case of International Catholic Migration Commission versus Calleja. Can inferior courts exercise judicial review? Yes. Since the power of judicial review flows from judicial power and since inferior courts are possessed of judicial power, it may fairly be inferred that the power of judicial review is not exclusive to the Supreme. Does the Court of Tax Appeal have the power to issue writs of certiorari? Yes, Section 1, Article 8 vests judicial power to the Supreme Court and in lower courts as established by laws. Judicial power includes the determination whether there has been abuse of discretion on the part of the government. The CTA has the judicial power to determine whether the RTC gravely abused its discretion in issuing an interlocutory order in cases falling with its exclusive appellate jurisdiction, based on the case of City of Manila versus Grecia. Well, what is a moot and academic case? It is one that ceases to present a justiciable controversy by virtue of supervening. so that a declaration thereon would be of no practical value. As a rule, courts decline jurisdiction over such case or dismiss it on the ground of moot, based on the case of Gonsi Sr. versus Commissioners. As a general rule, courts will not entertain moot questions, or the exception. The exceptions are first, when there is a grave violation of the Constitution; second, when there is an exceptional character of the situation and paramount public interest is involved; third, there's a need to formulate controlling principles to guide the bench, the bar, and the public; last, the fact that the case is capable of repetition yet evading review. Based on the case of international service for the acquisition of biotech application versus Greenpeace. What is the operative fact doctrine? When a said legislative act or executive act is found by the judiciary to be contrary to the Constitution, it is null and void. However, the existence of a statute prior to such determination is an operative fact and may have consequences which cannot be erased by a new judicial declaration. Thus, for a period of time, such statute, treaty, executive order, or ordinance was in actual existence, it is considered as an operative fact, based on the case of CIR versus Rock Power Corporation. When is the operative fact doctrine not applicable? Okay, based on the case of Planters versus Certified, an operative fact is not applicable if it will constitute unjust enrichment. And based on the case of Philippine Coconut Authority versus the Republic of the Philippines, it will not be applied if it will result in injustice. Can an administrative practice be the basis for applying the operative fact doctrine? Now, for the operative fact doctrine to apply, there must be a law or an executive issuance invalidated by the court. Its effect in administrative practice, relied upon by the public in good faith, may have to be recognized as valid, based on the case of CIR versus Rocky Power Corporation. Should the operative fact doctrine be applied to the Disbursement Acceleration Program or the DAP? Yes, the operative fact doctrine can be applied to the Disbursement Acceleration Program because it is an executive act. This doctrine, in the interest of justice and equity, can be applied liberally in broad sense to encompass said decisions of the executive branch. Um, it is important to note that the DAP resulted in public infrastructure. Not to apply the doctrine of operative fact to the DAP could literally cause the physical undoing of such worthy results by destruction, and would result in the most undesirable wasteful, based on the case of Araulio versus Aquino III. What are some of the examples of Supreme Court's judicial independence seen in the Constitution? First, the Supreme Court may not be deprived of minimum, original, and appellate jurisdiction. Appellate jurisdiction may not be increased without its advice or concurrence. Second, the appointees to the judiciary are nominated by the Judicial and Bar Council and not subject to confirmation by the Commission on Appointments. Third, the Supreme Court has administrative supervision over all inferior courts now. Fourth, the Supreme Court has the exclusive power to discipline judges or justices of inferior court. Fifth, members of the judiciary and security of tenure which cannot be undermined by law, reorganizing the judiciary. Last, the members of the judiciary may not be designated in any agency performing quasi-judicial or administrative functions. As a general rule, the constitutional question should be raised at the earliest opportunity. What are the exceptions? First, in criminal cases, the question can be raised at any time at the discretion of the court. Second, in civil cases, the question can be raised at any stage of the proceedings if necessary for the determination of the case itself. And third, in every case, except when there is an open, it can be raised at any stage if it involves the jurisdiction of the court. Based on the case of People of the Philippines versus Guerra, when the constitutional question is merely a small issue in the should the courts rule on it, the decision on the constitutional question must be determinative of the case itself. So no, the courts will not touch the issue of constitutionality unless it is truly unavoidable and is very crux. It is the if it is the very crux of controversy. Discuss the judiciary's fiscal autonomy. Okay, it refers to freedom from outside control. Pursuant to the constitutional mandate, the judiciary must enjoy freedom in the disposition of funds allocated in appropriations law. It knows its priorities just as it is aware of the fiscal restraints. The chief executive, I mean, the chief justice must be given a free hand on how to augment appropriations where augmentation is based on the case of Bengzon versus Drilon. May the legislative, being vested with the power of the purse, reduce the appropriations to the judiciary? The answer is no. Appropriations may not be reduced by the legislature below the amount appropriated from the previous year, and after approval shall be automatically and regularly based on Article 8, Section. May the legislature make a law exempting specific entities from the payment of filing fees? The answer is no. The legislature may not make a law exempting specific entities from the payment of filing fees because it encroaches on the fiscal autonomy of the judiciary. The fiscal autonomy of the judiciary, guaranteed by the Constitution, recognizes the authority of the Supreme Court to levy, assess, and collect fees. Congress cannot amend the rules promulgated by the Supreme Court for the payment of legal fees, granting exemptions based on the case of um, in the exemption from payment of court and sheriff fees of duly registered cooperatives. May be a member of the judiciary. Based on the 1987 Constitution, Article 8, Section 7, a member of the judiciary must be a person of proven competence, integrity, probity, and independence. What, what are the qualifications for a Supreme Court justice? The Supreme Court justice must be a natural born citizen of a judge of a lower court or engage in the practice of law in the Philippines for 15 years or more, should be at least 40 years of age. What are the qualifications for a justice of Court of Appeals? They should be a natural born citizen of the Philippines, a judge of a lower court, or engaged in the practice of law in the Philippines for 15 years or more, Basically, the same qualification as provided in the 1987 Constitution for justices court, and should be at least 40 years of age. For regional trial court judges, what are the qualifications? Should be a natural-born citizen of the Philippines, should have been engaged in the practice of law in the Philippines or has been in public office in the Philippines requiring admission to the practice of law as an indispensable requisite for at least 10 years, and it should be at least 35 years of age. For first level courts, what are the qualifications? Should be a natural born citizen of the Philippines, he has been engaged in the practice of law, or has held public office in the Philippines, requiring admission in the practice of law as an indispensable requisite for at least 5 years. Should be at least 30 years of age. Who are the members of the Judicial and Bar Council? First, the Chief Justice as ex officio chairman. Second, the Secretary of Justice. Third, a representative of the Congress as ex officio member. Fourth, representative of the integrated bar. Fifth, a professor of law. Sixth, a retired member of the Supreme Court. Seventh, representative of the private sector. Based on Article 8, Section 8 of the Constitution. What is the principal function of the Judicial and Bar Council? The Judicial and Bar Council, or the JBC, shall have the principal function of recommending appointees to the judiciary. It may exercise such other functions and duties as the Supreme Court may assign it, based on Article 8, Section 8 of the 1987 Constitution. What are the incidental functions of the Judicial and Bar Council? The functions of searching, screening, and selecting are necessary and incidental to the JBC's principal function of choosing and recommending nominees for vacancies in the judiciary for appointment by the President. In carrying out this main function, the JBC has the authority to set the standards or criteria in choosing its nominees for every vacancy in the judiciary, subject to the minimum qualifications required by the Constitution and law for every position. Based on the case of Villanueva versus King. This is important. What cases must be decided by the Supreme Court and banc? First, all cases involving constitutionality of a law, an international or executive agreement, and a treaty. Second, all cases involving the constitutionality, application, or operation of presidential decrees, orders, proclamations, ordinances, all regulations, and instructions. Third, all cases required to be heard in bank under the rules of court. Fourth, appeals from the Sandigan Bayan and from constitutional. Fifth, cases heard by a division uh, where required majority of three was not obtained. Sixth, cases where the Supreme Court modifies or reverses a doctrine or applicable law laid down by the Supreme Court en banc or by a division. Seventh, administrative cases to discipline or dismiss judges of lower courts. Eight, election contest of presidents, vice president. Based on Article 8, Section 4. Take note that the other cases outside the enumeration are heard in division and decided or resolved with the concurrence of the majority of the members who actually took part in the deliberation on the issues and voted thereon, but in no case without the concurrence of three such members is a law fixing the passing grade the bar examination at 70, with no grade lower than 40 in any subject. Constitutional? The answer is no. Such law entails amendment of the rules of court promulgated by the Supreme Court. The Constitution has taken away the power of Congress to alter the rules of court. The law will violate the principle of separation of powers based on the case of Nare. How does the Supreme Court exercise administrative supervision over lower courts? The mere division of the Supreme Court may discipline a judge of the lower courts, including justices of the Sandigan Bayan or Court of Appeal. The Supreme Court is required to decide a case only when the dismissal of a judge is involved. So again, a division may discipline a judge of the court. The SC is required to decide a case en banc only when a dismissal of a judge is. May the Ombudsman initiate or investigate a criminal or administrative complaint before his office against a judge? No. The Ombudsman may not initiate or investigate a criminal or administrative case before his office against a judge. He must first endorse the case to the Supreme Court for appropriate action, based on the case of Fuentes versus Office of the Ombudsman Mindanao. In civil cases, what is the exclusive original jurisdiction of the court? Okay. Petitions for issuance of writ of certiorari, prohibition, and mandamus against the following: Court of Appeals, Commission on Election and Bank, Commission on Audit, and Sandigan Bayan. In criminal cases, what is the exclusive original jurisdiction of the Supreme Court? Petitions for issuance of certiorari, prohibition, and mandamus against the following: Court of Appeals and Sandigan Bayan. In civil cases, what is the appellate jurisdiction of the Supreme Court? The appellate jurisdiction of the Supreme Court. First, appeal by petition for review on certiorari from appeals from the CA, from the Court of Tax Appeals, from the regional trial court exercising jurisdiction. Second, if no question of fact is involved and the case involves first the constitutionality or validity of a treaty, international or executive, a law, a presidential decree, proclamation, order, instruction, ordinance, or regulation, or a legality of tax, imposed assessment or toll or penalty in relation thereto, or cases in which the jurisdiction of lower court is an issue. Third, all cases which only errors or questions of law are involved. Fourth, special civil action of certiorari filed within 30 days from against the Commission on Election or Commission on Audit, based on Section 5 of Article 8. Criminal cases. What is the appellate jurisdiction of the court? Based on Article 8, Section 5, Paragraph 2, in criminal cases involving offenses from which the penalty of reclusion perpetua or life imprisonment, and those involving other offenses which, although not so punished, arose out of the same occurrence or which may have been committed by the accused on the same occasion.